evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we have a packed agenda of issues to discuss this evening. I want to welcome our viewers who are joining us on television from West Coast Berbice. Welcome to another program of Issues in the News. To our viewers who are also joining us on television from region number 6 along the east bank of the Berbice River, New Amsterdam, Kanji, and all along the Quarantine Coast and all the way to Siparuta. Welcome to another program of Issues in the News. To our friends who are joining us on Freedom Radio from Rob Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us on Facebook Live across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, and last week I saw people looking at us from the Middle East, Saudi Arabia, Dubai, Australia. So far, people are following this program. Welcome to another program of Issues in the News, and share this live. Press the share button on your phone, on your computer, on your iPad, or whatever the device is that you are viewing this program on. Share it so that your friends, so that your followers, and so that those who are on your contact list can join us in tonight's discussion. Again, I repeat, please circulate, please share the live, press that share button on your phone so that your friends and your followers can join us in tonight's discussion so that we can have the widest possible discussion. Please also include in the comment section your comments, your questions, and whatever query you may wish for me to address. I will try my best to answer them or to address whatever concerns you raise. Also, I want to make this program an interactive one, so we can speak by me reading what you would like me to address, and hopefully I get the opportunity to do so. So I want to begin by revisiting an issue that I spoke about last week, and that is the use of the social media by certain personalities. These persons use the social media only, it appears, to attack the reputation and character of others. They scandal and scandalize people's family. They publish the nastiest and most humiliating information about people's personal life. I have no doubt that most of them are untruth, but something has to be done about the use of the social media as a weapon against the citizens of this country. It is not freedom of expression. There is no jurisdiction in the world where that would be countenanced and categorized as part of freedom of expression. It is not. In fact, it is the abuse freedom. It is the abuse of freedom of expression. And a government cannot stand idly by in the face of such onslaught on its citizens. That government will be failing in its responsibilities. An Attorney General and Minister of Legal Affairs cannot stand idly by without doing what is necessary to address this horrendous development. And this government will not stand idly by. As I said, there is no country whose laws, none, including the United States of America, where the laws are quite liberal, nowhere the laws will justify or permit the type of publications that emanate from these social media platforms. So the time has come in Guyana for us to pay serious attention to regulating cyberspace, because currently it is completely unregulated, and it is the platform for the slaughtering of people's reputation, people's character, people's social lives, and the lives of their family. And these attacks are causing tremendous damage to people's reputation, people's character, and that of their family, and social relations in the country. And a regulatory framework must be installed, and installed very quickly, to arrest this situation. And the penalties for violation of this regulatory framework must be condign. What we have here is an exceptional situation, and an exceptional situation requires an exceptional response. My area of responsibility is the law, and the law is one of the main mechanisms to regulate human conduct and regulate human affairs. What has happened in Guyana, and what has happened with the social media, is that there have not been commensurate reform and regulation, and the social media has run ahead of the regulatory framework. So now they are without regulation. The duty of a state and the responsibility of the government holding office in that state is to bring regulation to that which is unregulated and causing public harm. And this onslaught emanating from the social media platforms, are causing public and private harm in this country. And it will not continue without a reaction from the government. So various steps will be taken. I have spoken already, and the government rather, has said repeatedly that the Cyber Crime Act will be reviewed. Well, it is under review, and the review will be completed for amendments to be taken to Parliament when Parliament resumes. We had indicated that we were working as part of a team at the level of the United Nations to craft a new convention that will govern cyberspace and the use of cyberspace, etc. The work on that convention is still ongoing, but we have completed our participation. And those who participated on behalf of Guyana have reported that they are in a position to work on the amendments which would owe their genesis in that convention. Whenever that convention comes into being, our experts who were there have informed us that they are in a position, having worked on the convention, to now inform the amendments that should take place in our Cybercrime Act in keeping and in compliance with the standards set in the convention. So while the convention may not be ready, our experts, Ms. Joanne Bond, Deputy Chief Parliamentary Counsel, and Ms. Trishala Prasad, participated from the inception on the work on that convention, and they have advised us that they are in a position to inform us on what the convention will say and how we should fashion our amendments to the Cybercrime Act. And we plan to do so. We plan to do so, and that those amendments will be ready for when the recess ends. The Law Reform Commission with whom I met today is also tasked with the responsibility of reviewing our criminal procedure statutory provisions and to make amendments to allow for documents to be served smoothly on persons who are overseas but using cyberspace to commit offenses in Guyana. They have been also tasked to review the current criminal law procedures to ensure that other procedural matters are addressed in amendments that they will be drafting. So that technical legal objections of the type that have been raised cannot be raised when those amendments have been effected and enacted as law. Issues such as which court has the jurisdiction to try the matter, how service must be effected, who can serve the documents, are not going to be questions of contest anymore. We are going to settle all those matters because cyberspace has become as equally a dangerous place as physical space that we currently occupy. It has become equally dangerous because the truth of the matter is that it is used as widely perhaps as we use our physical space. But it is hardly regulated. There are hardly laws which govern our use of cyberspace. You and I are interacting currently on cyberspace. Every day, every hour of the day, you interact on cyberspace. But there is hardly legislation which regulate how you should behave and how you should conduct yourself. We cannot continue in this way any longer. This thing has now moved from being a social media platform to an anti-social media platform. There's nothing social about this platform when you use your platform to wage war and as a weapon against unsuspecting citizens. So I thought that I'll begin the program with those opening remarks. So we are going to have massive reforms of our law to bring cyberspace into regulation. And let me assure the critics who will jump on the bandwagon to say that we are interfering with press freedom and freedom of expression, to say to them that we are doing no such thing. That freedom of expression and freedom of the press do not include any freedom or any right to attack people's character and to attack people's family and to attack people's reputation and to invade people's private lives. Freedom of expression authorizes no such thing. Freedom of the press does not authorize any such thing. So this is not an attempt to curtail freedom. Every right-thinking member of this society will know that no freedom is absolute. Freedom carries responsibilities and restrictions. Any freedom that is boundless will result in anarchy. It is not freedom. It is something else. An inherent component of freedom is the responsibility that flows with it. Because while you have a freedom to speak, I also have a freedom to be protected from your speech. And you can't use your speech to destroy and damage my character, because I have a right to protect my character from your freedom of speech. So there is that countervailing balance which must be struck. I spoke about this for about 2 hours in a lecture which is on the Facebook. Those who wish to interrogate this matter further, they can go and listen to what I said, because I ensured that I had my views supported by provisions of the Constitution of Guyana and the Constitution of several countries, as well as judicial interpretations of those constitutional provisions. So I thought that I'd put that on the record for those on that matter. The Law Reform Commission, as I said, 3 of the members whose tenure expired have been sworn in by His Excellency the President today, as they were reappointed. So the Law Reform Commission is fully complemented, and I want to take this opportunity to congratulate the members who were appointed, Mr. Tenny Usti, Ms. Clarissa Reel, and Ms. Dinawati Pandey. They were all members before, and they were reappointed and took their oath today in this new tenure. As I said, they have been tasked with the responsibility of working with the drafting department of the Attorney General Chambers on these issues of bringing greater regularity to cyberspace. Another very important issue that I want to speak about is something that has been going on in Guyana for a long time, and that is the sale by neighboring democratic councils in particular and municipalities of lands which are public lands that fall within the locality where they have jurisdiction. You would know that at a particular NDC on the east coast of Demerara, a controversy erupted about 2 years ago where backlands of the NDC was being sold by councillors of the NDC. I have examined the law, and the relevant law in relation to the NDCs is the Local Government Act, Chapter 2802. The Local Government Act, Chapter 2802. And it says very clearly in several provisions, and you can look at Section 47 and Section 48 and Section 106 and 103. Those are the relevant sections of the Local Government Act. It speaks to public lands within the NDC locality, and it speaks to how the NDC can treat with these lands. Insofar as it is relevant, the NDC cannot rent or, most importantly, sell these lands without the consent or permission of the Minister of Local Government. Let me repeat it. NDCs have no power to rent or sell land within their NDC. State lands, public lands, government lands, reserve lands within their NDCs without the consent or permission of the minister. The information which we have received is that several NDCs are selling lands. The information we receive is that the councillors themselves are buying these lands and other members of the public. About 2 years ago, I advised the Minister of Local Government of his powers, and I advised him to write to every NDC and municipality in the country to remind them of the statutory provisions which prohibit the sale of lands within their communities, their localities, public lands, government lands, reserve, government reserve, etc. Of course, they can't sell private lands. That goes without saying. So the lands I'm speaking about are the public lands, the government reserves, the NDC reserves within the locality where the NDC exercises jurisdiction. The minister wrote to the various NDCs in the country advising them of the relevant statutory provisions. Notwithstanding the warning from the minister and the reminder of the law, the reports that we are receiving is that this is actively taking place. Well, a couple of things will happen. One, the matters are going to be reported to the police because there is a serious series of criminal offenses that are being committed there by both the buyer and the seller. So the police will be called in because it's obtaining money, because the sale is contrary to the statute. It's illegal. So those who are purporting to sell really cannot sell, therefore they are receiving money by falsely pretending that they can sell. So that's obtaining money by false pretenses. It is fraud. And if the buyers, those who buy, they are also participes criminis because they are a participant in the crime. So they will also be implicated. They are implicated. Persons will be charged and placed before the courts. Of course, they will lose the monies that they have paid. And those who have received these monies will have to account for them. And the sales will not be recognized by the state. The sales will not be recognized by the state, because the sale is illegal and constitutes a criminal offense. So NDCs who are engaged in these activities, you are given notice publicly. The actions will start to unfold in a few days. The municipalities are governed by the Municipal and District Councils Act, and they have similar restrictions in respect of lands which fall within their domain. Chapter 2801 imposes upon the municipalities similar restrictions in relation to lands, public lands, state lands, reserves, etc. The minister's permission has to be obtained. And wherever the law is unclear, we are going to go to the Parliament and amend it, if it is unclear. In my view, it is not. These persons are elected to the NDC. Nobody elected them to sell public property. These reserves and areas that have been reserved for public use are there for future use by the community for the public good. That is why the law in its wisdom never empowered the NDCs to sell. That is not a function of an NDC. And that is why a higher approval is required by the law. So let me see your comments. I will continue shortly. The people are saying close up the gaps in the law. Yes, definitely. And persons are asking me to explain the issue with City Hall and the waiver for political parties. Now, I read in one of the national newspapers of the country that a letter came from the AFC, the Alliance for Change, which prompted the move at City Hall. Hopefully that letter will be made public. Another issue has arisen, and it is that those who moved the motion now want to distance themselves from the motion by trying to hoodwink the population in relation to what the motion actually says. I read a report, a letter in today's Stabrook News, I think, from one councillor, an APNU councillor, a PNC councillor. And this gentleman, I don't know if he believes that the people of Guyana cannot read and write. The man wrote a letter in which he denies that the motion seeks to exempt political parties from paying taxes. He says the motion was, read the letter in today's paper, read the letter in today's Stabrook News by a Saul, Mr. Leon Saul, I think his name is. A person whom I presume is an educated man. I believe there is a DR in front of his name, signifying that he's a doctor of some sort. And he writes a letter in the Stabrook News in which he tried to obfuscate the issues by pretending that the motion doesn't deal with and does not intend to exempt political parties from taxation. So let me go to the motion itself and read it for you. And I have the motion here. This is the motion. I got a copy from someone. Oh, the man said the purpose of this motion was to institutionalize rate policy. And he doesn't explain what that means. But let me go to the motion. It says, the municipal, I'm going to read the relevant parts only. The Municipal and District Councils Act, Chapter 28:01, Section 214, grants council the authority to exempt certain taxpayers from paying rates and taxes, right? So that's the whereas clause. That the Municipal Act exempts the council, authorizes the council to exempt certain taxpayers from paying taxes. According to the legislation, they're quoting the legislation, they're referring to the legislation. Political parties that own properties that have been in existence for more than 10 years are considered social and welfare institutions. The Act doesn't say so. I'll read the Act. But they are saying that the Act says so. This SOP outlines the rationale and process for exempting political parties regarding taxes, regarding paying rates and taxes in the city of Georgetown. What is mystifying about that? Let us go to the purpose. There is a section called Purpose of the Motion. The purpose of this SOP, that's what they call it, a SOP. The purpose of the SOP is to guide the City Council on how to implement the exemption of political parties from paying rates and taxes in line with the provisions of the Municipal and District Councils Act, Chapter 2801, Section 214. Are you in doubt what this SOP seeks to do? It says in very clear and simple language, it is to guide the City Council on how to implement the exemption of political parties from paying rates and taxes in line with the Municipal and District Council Act. That's the purpose of it. The motion says that. And they list now how political parties will qualify for this exemption. Identification of eligible political parties. And they tell you how the political parties themselves must be qualified. They must be over 10 years, they must own the property over 10 years, etc., etc. And then it continues on the other side, the whole page, on the other side. The application process. Let me read that for you. Political parties seeking exemption from paying rates and taxes should apply to the Town Council Finance Department. They are telling you now, after they pass this, how you will apply. Political parties seeking exemptions from paying rates and taxes should apply to the Town Council Finance Department. Full stop. The application should include proof of property ownership, evidence of continuous existence for 10 years, and any other relevant documentation required by the City Council. And then the next part of the document deals with how they will review and approve the application. And here how the SOP ends. This SOP establishes a clear framework for exempting political parties from paying rates and taxes in accordance with the Municipal and District Council Act, Chapter 2801, Section 214. These people are with a, I don't know, something is wrong in this country. These people are publicly denying in letters to the newspapers that this document that they laid before the council, they are denying that this document seeks to exempt political parties from paying taxes. They are looking at you straight in your face and telling you, no, it's a different document. He doesn't say so. And I have the document here. Alfred Mentor, his name is at the bottom. Alfred Mentor, JP, COA, meaning Commissioner of Oaths and Affidavit, Mayor of Georgetown, Mayor and City Council, City of Georgetown, on one hand, and the Town Clerk, Candace Nelson, Town Clerk, Mayor and City Council on the other hand. These are the two persons who are supposed to sign the motion. And they are denying that this motion says what the motion says that I just read to you. This is the vulgarity and blackguardedness that I'm speaking about. The same way this bunch claims that they win the elections, they won the elections of 2020 and can't produce their SOPs. when the world saw that they not only lost the elections, but they tried to steal the elections, they convert that narrative that they were the victims of fraud. And here it is, again, they have put forward a document that says clearly on its face that they want to exempt political parties from paying taxes, and now they are denying that the document says that. I hope the newspapers will get a copy of this document and publish it, the entirety of the document, so that you can see. I will try to put it, I will ask my operators to put it on my Facebook page so that you will see it. And you will not be in doubt. I can't believe that these people would lie with such a bare face. And this is what they're trying to do. So let's go to the, I have with me here the relevant section of the City Council Act, the Municipal and District Council Act, Section 214. The marginal note of Section 214 reads, power to exempt owners of certain properties from rates and taxes. That's what it reads, you know. And they're coming under the same section. And yet they're telling you that they're not doing that. Repeatedly throughout this document, they quote Section 214. This is the very 214. Now, 214 says that the council shall have the power to exempt a certain category of properties from rates and taxes. And the categories are any property used for the advancement of religion, education, or social welfare, not with a view to profit. That is one category. So any educational, religious, or social welfare organization that has a property and they are a non-profit, then they are exempt from rates and taxes. The next category deals with any property used for the purpose of sports, and it is non-profit. And the third one is any property used exclusively for hospitals, dispensary, or public health institutions. That category of buildings are also exempted. So those are the three categories. Now they want to fix political parties into category A because they can't fix it in the sports category. It's not a sports organization. They can't fix it in the medical facility category. So they are vulgarizing the English language to force it down into category 1. So category 1 says any property used for the advancement of religion, education, or social welfare, but is non-profit. So they want to classify political parties as a social welfare organization. And here what they say, listen to the fraud. They said this: according to the legislation, political parties that own properties and have been in existence for more than 10 years are considered social and welfare organizations. I just read the section to you. It says nothing like that. It says nothing like that. Let me read it again. According to the legislation, political parties that own properties and have been in existence for more than 10 years are considered social and welfare institutions. I just read section 214 to you. They are reading in all of this into section 214 to justify the corrupt act of writing off taxes for their political masters. This is one of the worst acts of betrayal of an electorate that I have seen committed by an elected body in recent times. this. Now, I heard the mayor glibly saying that PNC doesn't owe taxes or this is not intended to help the PNC. You know why he's saying so? Because Congress Place and all the assets of the PNC have been transferred into a limited liability company. So he's being technical. He's playing a bright boy. That PNC doesn't own property. And therefore he's not writing off or seeking to exempt PNC from rates and taxes. He's not telling you that it's a company whose taxes he wants to write off, and that company is the holder of all the PNC assets. They have been transferred over to that company, including Congress Place, I'm told. And these people have the audacity and courage to show their faces in the public. This is the most disgraceful act I have seen. And they're seeking to defend it. They're seeking to defend this. And I am told that it was generated by an AFC letter requesting this move to be made at the level of the City Council. Because they may also be owing taxes for the property that they own, or the properties that they own. I don't know how many properties they own. So we'll move on. Many of you have sent me many messages complaining bitterly about noise nuisance. In particular, you have identified areas where you claim noise nuisance is unbearable. Let me make it clear again that noise nuisance is a criminal offense under the Summary Jurisdiction Act, and it carries a fine as well as imprisonment. The making of loud, continuous noise is a criminal offense contrary to Section 174A of the Summary Jurisdiction Offences Act, and the fines are stated here, and there's a term of imprisonment as well. The police will be enforcing these sections of the law. If it is that we have to increase the penalties, as we plan to do in many traffic offenses, we will do that in relation to noise nuisance. Under the Environmental Protection Act, there are rules, and under Part 4, Part 5, any person who is guilty of an offense of noise nuisance or loud noise nuisance are also liable on a summary conviction to a fine of not less than $300,000, nor more than $750,000 and imprisonment for a year. So under the environmental legislation, the fine is 300,000 and not less than 300,000 and not more than $750,000 with a month imprisonment. And then you have another offense of a similar type. So section 13 and 14 of the Environmental Protection Regulations create these offenses. The fines are high. The terms of imprisonment is for an entire year. This section says anyone who contravenes paragraph 1 commits an offense and is liable on a summary conviction to a fine of not less than $75,000 nor more than $500,000 and to imprisonment for 6 months. So you have a 1-year fine, you have a 6 months fine, you have a $350,000, a 1-year imprisonment, a 6 months imprisonment, a $350,000 to $750,000 fine, and a $75,000 up to $500,000 fines. If this is not adequate, then we will have to impose more. I keep saying, while you can make noise and while you can play loud music or play music, you cannot play it so loud that it will constitute a nuisance to your neighbor. Because in the same way that you have a right to listen to your music and enjoy it, the neighbor has a right not to hear it. The neighbor has a right to the peaceful and quiet enjoyment of his or her home. So you have to enjoy your freedom in a balanced way. You have to enjoy your freedom in such a manner that your neighbor enjoy his as well. And if he doesn't want to hear your loud music and he wants to enjoy the peace and quietude of his home, well then that balance must be struck. And that is what the law compels and imposes. So again, this is an issue that is causing tremendous problems right across this country. It applies as well to vehicles. I am on the road and some vehicles pass me playing music at deafening levels. First of all, those who are in those vehicles are deaf. I have no doubt about that. They are deaf. Because there is no way that a sane man whose hearing is intact can be listening to music or listening to anything at that level. And this is what is called noise pollution. And the police have the power to seize the noise-making instruments as well. And perhaps it's a draconian thing to do, but perhaps we have to start these campaigns all over again. We used to have these campaigns, I remember. And perhaps we have become relaxed and laxed, and now persons are exploiting the situation. This pollution of our environment cannot continue unabated. It cannot continue unchecked. And the police will be acting swiftly, and I've already consulted my colleague, the Honorable Minister of Home Affairs, and if it is we need greater penalties, then we will take the proposal to Cabinet for Cabinet's consideration. Speaking for myself, I can't handle loud noises. I will tell you that. I can't. But I don't want to judge people by my standards. Neither do I want to impose my standards on people. Let us use the objective, reasonable man test. That's how the law views things. Not because I have some peculiar idiosyncrasy, then I must impose that. No. The country can't be managed like that. We have to use what the ordinary decibel is, acceptable to the reasonable man. And once we find that, and we have found that already, when we brought in the machines in Guyana for the first time, we did those tests. So we know what is acceptable and what is not acceptable. And once you go above that which the machine records as acceptable, then you have committed the offense. And you are liable to one of the regimes of punishments to which I have made reference. So I want to thank you very much. My operator is signaling to me that we have arrived at the hour. Thank you very much for spending the past hour with me. I believe that we have covered some good grounds. We have discussed some important issues. And please enjoy the rest of your evening and enjoy the rest of the week until we meet again next week to continue our discussions. Take care and may God bless you. Thank you.